There is an interesting article titled Reflections on an Atheist Epic in Microform by Jim Bowman, Eric Clearinghouse, 1989, concerning the landmark Supreme Court case O'Hare versus Curlett discussed above. Madeline Murray O'Hare and Baltimore Sun reporters comment about the coverage of the first incidents leading to the Supreme Court's banning religious readings and prayers in the United States public schools. Bowman read all the copies of the Baltimore Sun from 1960 to 1962 pertaining to the O'Hare case and found 5 revealing facts concerning press coverage of this important case. 1. There was an imbalance in the disproportionate amount of space given to authorities and proponents of school prayer. 2. Atheism was linked to communism, a distortion of the facts. 3. The press was quick to stereotype atheists and did not understand dissent in the form of atheism. 4. 2 reporters' professional judgment was skewed because of disliking O'Hare. And 5. There were one-dimensional portraits written of O'Hare and her son. They were not depicted as individuals. Not enough attention has been paid to an earlier case, McCullum versus Board of Education, 1948, which was another landmark case. See AtheistScholar.org for the documentary shown on PBS in 2011. Robert Boston states that all subsequent church-state decisions involving school prayer, state aid to parochial schools, and sectarian religious displays on public property by states and municipalities descend from the McCullum case. Vashti McCullum was a professor's wife and a college teacher who decided to challenge a policy in her son's school that pressured students to enroll in a Christian religious education program offered during school hours. The case's significance, says Boston, was that it was the first decision to hold states accountable to the strictures of the Establishment Clause under the Due Process Clause of the 14th Amendment, which makes provisions of the United States Constitution binding on all the states. The McCullums allowed their son, Jim, to attend the classes for the balance of the school year at the start of the program. However, the following year, the McCullums, feeling that such a program was inappropriate in the public schools, refused further participation. After unsuccessful attempts to get the program discontinued, McCullum filed suit in the Champaign County Circuit Court in Illinois in the late summer of 1945. This became a challenging period for the McCullums, marked by physical confrontations between Jim and his peers, vandalism of the McCullum home, and unsuccessful efforts to end Dr. McCullum's employment at the university. He was protected by tenure, but her employment as an adjunct instructor in the women's physical education program was not, and she was terminated. A 3-judge circuit panel decided that in spite of the Illinois Constitution's clear language to the contrary, Champaign's religious education program violated neither the state constitution nor the Establishment Clause of the First Amendment to the U.S. Constitution. The Illinois Supreme Court agreed, and the case was appealed to the United States Supreme Court. On March 9, 1948, the Supreme Court handed down its landmark decision in McCullum versus Board of Education, finding for McCullum and against the schools in an 8-1 verdict written by Justice Hugo Black. Leben versus Kurtzman was another extremely important case decided in 1971 when the Supreme Court handed down a case that connected principles recognized in earlier religious funding and expression cases. Chief Justice Warren Burger established the Lemon test for determining whether or not a law has 3 criteria in order to be considered constitutional. It is still used today. The criteria are: 1, the law must have a secular legislative purpose. 2, its principal and primary effect must neither advance nor inhibit religion. 3, it must not foster excessive entanglement between government and religion. Many establishment disputes are settled by reference to Lemon. There are continual challenges to the effort to keep the United States public schools secular, as well as attempts on the part of private religious schools to receive tax dollars. This is an extended battle with such issues as voucher programs for private school tuition, using public buildings for religious extracurricular activities, and so on being brought before the courts. Religious fundamentalists are determined to bring religion and religious coercion into the public schools, and the secular community is determined to stop such attempts. One of the most important and far-reaching victories for the secular viewpoint was the Kitzmiller versus Dover Area School District, which effectively routed a new attempt to introduce creationism into the public schools of the United States. Creationists made their attempt under a new name, Intelligent Design. In 2004, the Dover, Pennsylvania School Board became the first in the nation to adopt a science curriculum indirectly promoting intelligent design. A group of parents represented by Americans United for Separation of Church and State, the ACLU of Pennsylvania, and the law firm of Pepper Hamilton challenged the plan to tell ninth grade students that copies of a book about ID, described as a scientific alternative to the theory of evolution they were about to study, were available in the school's library. The textbooks of pandas and people, they failed to mention, were donated by a local fundamentalist Christian church in an attempt to get religiously based curriculum back into the public school science classrooms. The case went to trial on September 26, 2005, and concluded on November 4th of the same year. The plaintiff's attempt was to show that the ID statement violated the Establishment Clause because the board lacked a secular purpose in adopting it. Their lawyers walked the court through 3 years of the school board's history, demonstrating how board members who were bent on getting creationism and school prayer back into the classroom had accomplished part of their goal with the ID statement. They cited at length the Wedge document, which is the Discovery Institute, which is a leading ID think tank in Seattle, Washington, the strategy for reintroducing religiously based creationism into public schools. The document states that the movement's goal is to defeat scientific materialism and its destructive moral, cultural, and political legacies, and to replace materialistic explanations with a theistic understanding that nature and human beings are created by God. Law professor Philip Johnson, largely considered the father of intelligent design, said of ID in 1996, "This isn't really and never has been a debate about science. It's about religion and philosophy." The joint legal team had a slam dunk case in proving that the statement lacked a secular purpose, but they also felt it necessary to show how the statement, in the students' eyes at least, endorsed religion. The simple fact that the statement flowed from school officials was enough to convince any reasonable student that the school endorsed its content. The decision from U.S. District Court John E. Jones III, a Bush appointee, came on December 20th, 2005. It was remarkable. Every detail, every excuse, every piece of evidence that was exposed during the 40-day biblical trial was painstakingly analyzed in Jones's 139-page opinion. The court decided that the ID policy did indeed fail Lemon's secular purpose test and chided the board for misleading it and the Dover community. The school board's flagrant and insulting falsehoods to the court, Judge Jones wrote, provide sufficient and compelling evidence for us that any allegedly secular purposes that have been offered in support of the ID policy are equally insincere. Jones also noted that the statement failed the endorsement test by sending a message to students that the district doubted the validity of a scientifically sound theory, and by presenting students with a religious alternative masquerading as a scientific theory, directing them to consult a creationist text as though it were a science resource, and instructing students to forego scientific inquiry in the public school classroom and instead to seek out religious instruction elsewhere. Each school board member who approved the unconstitutional statement, all but one of whom was up for re-election in 2005, had been voted out of office just 1 month before the decision came down. They were replaced by a slate of residents who campaigned on returning scientific integrity to the area's public schools by repealing the ID statement. Kitzmiller versus Dover Area School District was not appealed to a higher court. The path-breaking decision has served as a guide for courts and school districts considering ID curricula around the country. Indeed, in early 2006, it caused a school board in Lebec, California to drop an elective class in the philosophy of design, which taught almost nothing but anti-evolution propaganda. In 2007, the decision influenced school boards in Kansas and Oklahoma to abandon plans to include alternatives to evolution in statewide high school biology curricula. However, the fundamentalists never rest. Recently, there has been a move to include in school textbooks a description of the strengths and weaknesses of evolutionary theory, which as a matter of course is highly misleading. As of this reading, it has been in and out of the textbooks in Texas. Since Texas has such a high count of students, textbook decisions are frequently decided upon Texas policy, and publishers leave in material for other states that should be excluded and leave out material that should be included. Then, as we have looked at so often, there are the cases of peddling Christianity to the public schools by outside groups. The following case is an egregious example of the regularity with which the religious push their practices wherever they are allowed to encroach. In 2001, an evangelical Christian group called the Good News Club wanted to conduct religious education classes in a New York public elementary school just minutes after the school day ended. A number of church-state separation advocacy groups supported parents who were concerned that their elementary-age children would not be able to differentiate between private and school-sponsored meetings if the club met so soon after the students were dismissed for the day. The groups, along with some organizations, filed friend-of-the-court briefs arguing this point in Good News Club versus Milford Central School District. The club, on the other hand, claimed that the school district's blanket ban on renting school facilities to religious groups violated its free speech rights. The Supreme Court agreed with the club. The court's shifting stance toward government interaction with religion is evident in its decision favoring the Good News Club's discrimination claim. Tellingly, the majority opinion was authored by Judge Clarence Thomas, an outspoken proponent of states' currently unconstitutional power to establish an official religion.